individual name when you die. Okay. When you pass away, anything that's in your individual name is a probate asset, subject to the probate process, and it is going to go through the court system in Pennsylvania. Now, non-probate's a little bit easier to explain what that is. That is an asset that transfers by operation of law. What that means is when you die, it automatically goes to somebody else. It doesn't matter what your will says, or if you die without a will, what we call intestate. So you die with a will, it's testate. Without a will, it's intestate. Testate, your will governs where your probate assets go. Intestate, without a will, state law governs where it goes. If something is non-probate, it goes automatically to, say, the joint owner or the designated beneficiary, or if it's in a trust, it goes pursuant to the terms of those trusts. If you have POD, payable on death or transfer on death designations, then it'll go, obviously subject to those. The important consideration here is that there are two sides to your estate plan. First side, probate, your will governs it. Second side, non-probate, something else governs it. So when you're doing a will, you can't just assume, or your loved ones can't just assume that just because their will says I'm leaving everything to Bobby and Susie in equal shares, if they have an IRA that has a beneficiary designation and it says Bobby gets everything, Bobby's getting the whole IRA. Susie's not getting any of it. It doesn't matter what the will says. Even if the will says I give my IRA to Bobby and Susie, the beneficiary designation always will control over what's in the will because it is a non-probate asset. Things that have beneficiary designations are like a life insurance policy, an IRA, TODs and PODs you might see on bank accounts or investment accounts sometimes. Joint ownership could be joint tenants with right of survivorship. Is a very common way to title things jointly. You might see bank accounts titled jointly with a spouse or a child. And we'll get into that, why that's not a good idea to do that. Well, I'll tell you this. You don't want to have your children on bank accounts because you only get or on an investment account or on a piece of property unnecessarily because of step-up reasons. There's tax reasons why you don't want to do that. Proper planning through the use of beneficiary designations or TODs and PODs or a trust or just having it pass through your probate estate is usually much better from a tax standpoint because you get a step up, especially if you have low cost basis, what you paid for something versus what it is when you die. If it's in your estate, it gets a full step up. So it can be part of non-probate estate, but if it's a joint ownership, it only gets 50% step up because there's 50% owned by other people. So I don't want to get too much in the weeds on that. If any of you are thinking about just making everything saying, what I don't want you to take away from this is Brian said I should put my name on everything with my parents and then we won't have to go through probate. While that may be true, it's not a very good result for a number of reasons, the least of which is taxes. It also makes those assets subject to the claims of your creditors. And if you die before your parents do, then your parents have to pay tax on their own money because you're a joint owner now. Nevertheless, I wanted to just get that out there. That's not really the focus of tonight, but I just hear me when I say I'm not telling you to make everything non-probate assets and put your name jointly with your parents, because there are some lawyers that will tell you to do that, and that is very bad advice. So documents used in estate planning. We got wills. You can have a simple will that just leaves everything outright. You can have a will that has a trust in it. You can have trusts. Two big categories would be revocable and irrevocable. Power of attorney. You can have springing powers. You can have durable powers or general durable powers. You can have financial and healthcare. We'll get into that. And you can have living wills. That's more of like your advanced healthcare directives if you are end stage, terminal, or if you are permanently unconscious in a hospital and you can't make a decision for yourself. So again, simple wills, they don't really have any tax planning involved in them. They just appoint fiduciaries and guardians, and they typically dispose of assets to your spouse and then to the children or to whoever your residuary heirs are. Could be nieces, nephews, things like that. You can have trust related wills. A trust related will typically is going to either have a testamentary trust in it. It'll have it'll be a last will and testament that creates a trust upon your death, and that trust could be for minor grandchildren or children. It could be for special needs. It could be just for, you know, children or grandchildren that can't be trusted with money. A lot of reasons why you might want to do that. You can use pour over wills. You can use a will that just says everything in my probate estate goes to my revocable trust or my irrevocable trust, whatever you want to do there. But it basically keeps the terms of your estate plan out of the public eye for the most part, because the will gets probated. And by and large, it's more difficult for somebody to go look up and get a copy of your revocable trust. It's not impossible, because when you file an inheritance tax return in Pennsylvania, then it does show up there, but people have to dig pretty deep to find it. So some people do this for privacy purposes. Let's go into the trust. You've got revocable and irrevocable trust. They can be very simple. They can be very complex. Typically for tax planning and long-term care planning, we're going to be looking at irrevocable trusts, not revocable. Revocable trusts are good for a couple of things. They are particularly good for owning out-of-state property. So if you're a resident of Pennsylvania and you own property in a different state, they're very good at that, because if you own property in another state, a separate state from where you reside permanently, where you're a resident, you would have to go to that state. Your executor, if you die owning it individually, your executor has to probate your will in Pennsylvania. And then they also have to go to the other state to probate your will. It's called ancillary probate. You can avoid that by using a revocable trust to own that real estate. You can also avoid it by having the real estate in an LLC or anything else like that. But these are the types of issues you should be looking for with parents and yourself if you own property outside of the state where you reside. The main point here is that, you know, using trust is not only for wealthy people. Lots of people with hundreds of thousands of dollars use trusts, and they use them very effectively for long-term care planning purposes or for avoidance of ancillary probate. Let's go into these trusts just a little bit more. A revocable trust is not going to give you any sort of Medicaid planning or long-term care planning benefits. It will not give you any real tax planning benefits. You've got to basically use a irrevocable trust to do that. And for these things to work, you've got to give up some level of control over those assets by putting it into the trust. Now, you can give up that same level of control by just giving assets to your children or to somebody else. But the problem when you do that is that back to the tax reasons, if you paid $1, you know, if I paid $1 for this phone, then my cost basis is $1. If I die owning this phone and it's now worth $10 when I die and it's part of my estate, then it goes to my heirs and its cost basis is now $10 to them. And if they sell it for $10, they pay no capital gains tax. If you're alive and I give this phone if I give this phone to my daughter and I say, here you go, you can have this phone, and my cost basis is $1, if she then sells this phone at any time, me living or me dead, and she sells it for $10, she has to pay capital gains tax on the $9 gain. So we want to, in a lot of cases, trigger for a lot of people, we want to trigger inclusion of this phone in their estate so it gets a step up in cost basis, so that they're, and this holds true with stocks in a brokerage account or anywhere else. When we do trust planning, we have to take a very close look at whether or not we want to go after the step up in cost basis so that the kids or grandkids or whoever is inheriting the asset, we want to make sure that they aren't unnecessarily being burdened with capital gains tax. We want to chase the step up in a lot of situations. But then again, there are also times that we don't want to chase the step up. Either way, we can use an irrevocable trust for Medicaid planning purposes. We can put the assets into the trust. We can make a decision today whether or not we want to chase a step up later by how the trust is drafted. And we can say, okay, after 5 years, it's not an includable asset for Medicaid purposes, but whenever the owner of it dies, it may be included in their state for tax purposes, which means that it gets a step up in cost basis. Sometimes we don't really care about going after the step up, so we draft the trust a little bit differently. Again, after 5 years, not includable for Medicaid purposes, and also not after 1 year, it's not included in your estate for tax purposes either. Now, you don't get the step up at that point, but these are the types of considerations when it comes to the use of trusts that you'll typically hear a lawyer, at least one that knows what they're doing with this type of planning, talk about. They're gonna ask questions. You should be prepared to talk about, what did you pay for that asset? Like, if you're having conversations with your parents, that should be a major topic of conversation. Mom, dad, what is your cost basis in this asset? If you don't know what it is, you've got to be able to substantiate that somehow. And that absolutely is something that is taken. It is a huge discussion. I mean, Doug and Tim know that I harp on this with clients all the time. A large part of the discussion is cost basis related, because it really drives, from a Medicaid planning standpoint, which direction we're heading with these trusts. And it's a very big decision, and it's an expensive decision too. If you make the wrong decision, it could cost you a whole lot of money. If you make the right decision, it could save you a whole lot of money. So just wanted to get that in there, and we'll get, in about 10 minutes from now, we'll get to Medicaid planning, and we'll come right back to that. But another important asset that or document you really need to deal with marshaling of assets while somebody's still alive is a power of attorney. So the principal is the person that makes it. The agent is the person that's acting on behalf of the principal. They are not called the power of attorney. The power of attorney is the document. Okay. You can have springing powers of attorney that come into, they become effective whenever the principal becomes incapacitated, or you can have durable powers of attorney, which are effective from the date that they're signed. We don't use in this office, typically, 99 times out of 100, we use durable power of attorney. We do not like springing powers of attorney. They can cause some serious problems. I would advise you against having a springing power of attorney. It's just very difficult to substantiate when it becomes effective. You can define it all types of ways and say, upon my incapacity, but how do you determine if somebody's incapacitated? So we don't typically like to use those. What we use are general durable powers of attorney, 9 times out of 10, which cover both healthcare and financial. You can have a separate healthcare and a separate financial power of attorney. You can name separate agents, but the truth of the matter is, and everybody kind of knows this, as you get older, the line between what is healthcare and what is financial gets very blurred, especially when you're talking to the billing department at a hospital. So if you have 2 different people named to handle it, it can be a little bit difficult to get answers out of the billing department at a hospital, because they don't want to give you any medical information to the financial agent, and they don't want to give financial information to the healthcare agent. So these are considerations that you really have to take. You have to look at when you're doing these things. Which is the last point here, which is that these aren't really a commodity or form document anymore. We really do spend a lot of time tailoring these things. I mean, somebody can say they want it as a form document, and I'll give it to them, but we do spend a lot of time talking to clients about the various powers that are granted. And I have a note in here too about they're a useful alternative to other methods of achieving the same result. Sometimes people put inter vivos trust is really another name for a revocable trust, or joint ownership or guardianship. Those are all ways for you to control an asset of somebody else, because you could be the trustee of a trust, or you could be the joint owner on an asset, or you could be somebody's guardian, court-appointed guardian that allows you to act on somebody else's behalf. We really prefer to use a POA as opposed to all of those other things, because it's just more effective. Pennsylvania has very good laws on this. They update our Power of Attorney Act very frequently. It's very well defined, and all the banking and healthcare, financial and healthcare institutions are very well versed in them. So if you have a well drafted POA, it will open a lot of doors for you, to allow you to kind of, from a healthcare and a financial perspective, take care of your aging parent, or of a spouse, or of even a child. Your children should have them, honestly. And if they don't have their own spouses, they should be naming you or a sibling to make these decisions on their behalf, because it's very difficult these days to be able to talk to a healthcare or a financial institution. Living wills, we don't really need to get into this. What you need to know about this is it allows you to exercise your right of self-determination. It usually has a whole bunch of check boxes on it. You can check whether you want, CPR and blood products and antibiotics and all types of things, feeding tubes, hydration, if you're in an end stage condition, or you're permanently unconscious and you can't make a decision for yourself. You're doing your family a huge favor by having one of these, quite frankly. The only thing I would stress here, and this is the very last point, when you fill these things out, this is a form document, by the way. You can get free ones off the internet that work just fine. You can use the one that your doctor gives you. They work just fine. There is a statutory form in Pennsylvania that we use. Most of the palliative care physicians know what it looks like, so I like to use it because the ER, the trauma docs know what it looks like too. So if you show up at a emergency department, with multiple failing organs and everything else, you want it in your medical records. So the last point is make sure it gets scanned into your electronic medical records, because if the doctors or the hospital don't have it, they don't know what it says. So in the day of everything is electronic and all of these hospital systems talk to each other and share information, if you get it into a major hospital system like UPMC or Penn State Health or Penn, or any of the really big ones, they will upload it to your medical records, your electronic medical records. And if you present at a hospital on the other side of the country, it's likely that they will have that medical record pretty quickly, if they want to get it. So these things don't do any good if they don't have them on file. Same thing goes with healthcare powers of attorney, which really don't deal with end stage. They deal with more, they're more routine. If you're just not able to make a decision, if you are unable to make a decision for yourself and you go to a hospital, healthcare power of attorney, if you're not end stage, they'll still want to talk to the healthcare agent, but you got to get it on file with your doctor. You can't not have it on file. Otherwise it does you no good if it's in your, locked up in your gun safe at home. So, here's some other considerations. Life insurance is always a big consideration. Tim, Ralph, Doug, they know how much consideration. I mean, life insurance is excluded for Pennsylvania inheritance tax purposes, but included for federal estate tax purposes. So if you're a high net worth individual, your parents are high net worth individuals, buying and keeping life insurance can be a tricky situation if you're high net worth. Lifetime gifting, we encourage lifetime gifting. We like parents and grandparents and everybody else to take advantage of annual exclusion, which is $18,000 this year. Charitable donations, we like those too. If you don't need your RMDs and you're in a very high tax bracket, or even if you're in a very low tax bracket and you want to make charitable contributions, we encourage QCDs, qualified charitable distributions from your qualified retirement accounts. We like them, especially for people that don't itemize, because it's a way to get a deduction basically for charitable giving without actually having to itemize, because it comes right off the top. Long-term care planning, obviously, if you've got a history or your family has a history of any sort of diseases like Alzheimer's, dementia, that type of stuff, that would, or ambulatory issues where you can't get around so well, those it's probably a good idea to talk about long-term care planning. Pennsylvania inheritance tax is a consideration that goes into this. For those of you that don't know, spouses, the rate to spouses, everything you leave to a spouse is 0%. Anything you leave to a lineal descendant, which would be your parent or your children or your great grandchildren, or down through the line, that's 4.5%. If you leave something to a sibling, 12%, and everybody else is what we call collateral. Well, the state calls collateral. So nieces, nephews, everybody else in the world is 15%. That basically starts from $1. There are some deductions we can take against it, and there's a couple exclusions that we can take, but for the most part, it's $1. Federal estate tax, gift tax, which is called the unified credit or the generation skipping transfer tax, which is a different tax that kind of runs parallel to federal estate tax. federal state tax right now has an exclusion of, and the gift tax has an exclusion of 13.61 million per person. That is set to expire and roll back to about $7 million per person at the end of 2025. So it was increased by the Tax Cuts and Jobs Act. It was done through a reconciliation bill in the Senate, which is how the Senate does tax bills without getting the approval of the president or the House of Representatives. Very few people understand this, but they have a lifetime to them. They do sunset after 7 years. So it is going to roll back to pre 2017 levels, obviously adjusted for inflation. We expect that will be somewhere between $6 and $7 million per person. But that means that you can give away and or die with, or some combination thereof, right now $13.61 million without having to pay a penny in federal estate tax. But every dollar over that is taxed at 40%. Generation skipping tax is another one that they tried to go after the Rockefellers and the DuPonts for. And in 1985, when the new tax code was put into place, which went effective in 1986, they basically said that if you try to skip a generation, your generation skipping transfer tax credit is the same as the federal estate tax credit. They've run parallel to each other, but if you give more than $13.61 million to any generation than the next generation, so if you skip that generation and go to the next one, you could end up paying federal estate tax and generation skipping transfer tax for a whopping total of 80%. And then you add on top of that Pennsylvania inheritance tax, you're, to a lineal descendant, you're approaching 85% almost in death taxes. So something that you have to be very careful of. Not a lot of attorneys, they haven't really taught this stuff in law school in the last 15 or 20 years, just because it hasn't really been that big of an issue because the exclusions have been so high. But it is coming back around to haunt us as we speak. And it's certainly a consideration if your parents have, or if you are, in that $7 or $8 million per person plus category, something you should pay attention to. Long-term care planning basics. Now, this right here, this is very easy to understand. We don't need to spend a ton of time on this, but I'm sure some people have some questions. So let's jump into it. Same type of concerns. The obstacles here are almost exactly the same. Basically, people think they're never going to grow old and they're always going to be, strong and able to take care of themselves. And we know that that's just not true. Decline sometimes happens very slowly and people don't notice that they're declining. So having this conversation early and often, if you see decline happening, because we'll get to the pre versus crisis planning, you really truly want to have this conversation early and often. If your parents are over 70 or 75 years old and you start to see either physical or mental decline, now is the time, or if a spouse even is having that, now's the time to have that conversation. The cost, obviously, I'm going to tell you, we don't do crisis planning so much anymore. We kind of farm that work out, but the pre-planning, it's a lot cheaper to do pre-planning than it is to do crisis planning. The reason we don't do crisis planning is because it's very expensive and you never have, clients are happy, but they're not like really happy about having to spend tons of money on it. So we've just learned that it's not worth it for us. And it's very, very time sensitive type planning. So we try to stay away from it, but pre-planning is 5 or more years before somebody needs care. And quite frankly, it is half as expensive, if not less, maybe even a third. The reasons, obviously, people are living longer. When you're talking to parents or a spouse about this, the longer you live, the increased risk you have of needing some sort of, especially from a mobility standpoint. Typically, the older you get, you may be there mentally, but you won't be able to take care of yourself in a house by yourself. You might not be able to go up and down steps. You might not be able to get in and out of the bathtub or use the bathroom. So, the longer you live, the more likely it is that you're going to have trouble with mobility. Obviously, you can still have some mental, cognitive decline too, but it's certainly a consideration. Peace of mind for most people. I put that in there because it was part of a study where they said, people feel at ease after they do this type of planning. I think that's true, but I think getting somebody to do the planning is actually kind of difficult. And that peace of mind is not really on their mind at that point. They're just thinking, how much is this going to cost? And why do I really need to do this? Because I'm perfectly healthy right now. Um, asset preservation, notice I put for future generations, I put that one last. It's a consideration. Um, I will say that, our most wealthy clients, the ultra wealthy clients, their families have become ultra wealthy because they do a very good job at asset preservation. It takes a couple of generations to build significant family wealth. Even if it's a small number, you're just giving the next generation a leg up by preserving assets for them. It's an important consideration. It's also important for people to understand that if they want to spend their money on very, very high-end care, it's their money and they should do that. Some people are concerned about, wealth preservation, and again, giving that next generation the leg up. That doesn't always mean that you give the next generation all the money in the world that they'll never need and put no controls on it either, because sometimes that backfires and then you have the next generation that doesn't work very hard, and they just consume all the money you left them. So there's a very delicate balance with that last one there. But I think for some people it's very important, and it should be, because again, study after study after study has proven that the more inheritance people receive typically will lift families out of poverty or out of from one economic class to the next. So there's empirical evidence to support this stuff, but if it's done incorrectly, it can backfire. Just know that. So long-term care settings. This is in sort of a particular order. Obviously, the home is the big one that everybody wants to be taken care of and die in their own home. Not always possible, and it's very expensive sometimes. Independent living is usually in a facility that has either assisted living or skilled nursing care in the same facility, but they don't always have that. Some are just independent and assisted. The level of care at independent is usually not real great. They might do like cleaning of the apartment every once in a while, or they may have like a dining hall that they can go to. Usually you can look for anywhere between like $2,000 and $5,000 a month, sometimes a little bit more depending on where you are for this. Assisted living's a little bit more. You got people that'll come in and check, and they'll change bed sheets, all your linens and everything like that. You get a little bit higher level of care. They're going to be after you for medication and things like that too. This is usually in the $5,000 to $10,000 range. Skilled nursing care is the highest level of real care that you can get. This is the only one that Medicaid will pay for. So public benefits do not pay for assisted living, independent living. And by and large, they don't pay for in-home care unless your income unless you basically have no assets and your income is extremely low. And when I mean extremely, I mean like $2,500 a month or less. So they don't in Pennsylvania, at least, in-home care is not really an option for public benefits, but skilled nursing care is. Private pay skilled nursing care can be anywhere from about $10,000 a month to like $20,000 a month, or more, depending on where you are. Medicaid will pick up the tab once assets are spent down or planning is done to get assets to a certain level. And I'll give you some of those numbers here because I just updated them a couple weeks ago. Two types of planning really are pre-planning. This is 5 or more years before care is needed. This is cheaper typically than crisis planning. Crisis planning by its very nature is, you're going into a nursing home or your parents going into a nursing home and you got to figure it out right then and there. This gets a little expensive sometimes. And it's sometimes it's effective. Sometimes it's the only option, but a lot of times what I think happens is people put off planning and then this happens. It's not likely like, oh, mom had a stroke and she's going into a nursing home. Usually mom had pretty significant decline, years before that. So again, you should be looking for physical and cognitive decline. That's a good indicator that you should be engaged in pre-planning and not wait until it's a crisis. So levels of care, we went through that. Here's some numbers for you. Basically, the resource limits for an individual are about $2,400 before they would before they would qualify. Um, there's some exceptions. That's for a single individual. If you're married, there are certain assets that are exempt assets. You know, if one spouse, the community spouse, is staying out of the nursing home and one is going in, the house is a big exempt resource up to $713,000 worth of equity in the house. They'll exclude that as a resource. You know, if a spouse, if there's a child under 21, which we usually don't see, that lives in the house, it can be an exempt resource too. Or if you have a child who's blind or disabled that lives in the house, we can get it exempted then also. A lot of times we put the houses in trust just because it's an easy asset to put into trust. And we can put it in a trust that allows for a step up in cost basis. So after mom and dad are gone, children sell it, they pay no capital gains tax. They might pay some inheritance tax on it, but they won't pay capital gains tax when they sell it later. So that's one thing. One vehicle, if there's a spouse that's not in the nursing home, all the household goods and personal effects are all exempt. And prepaid burial plans are a big one. Pennsylvania allows you to prepaid burial plans. You should definitely do that as you get older. And if mom and dad don't have it, you should have them talk to a funeral director or the cremation society or whatever. They should have prepaid burial plans no matter what. It's cheaper. They give you a discount if you buy early. You know, who would have thought? So I would definitely encourage you to do that or have your parents do that. Um, exempt transfers of resources occur 5 or more years out. That's why we like pre-planning, but you know, you've got to do it. Asset protection trusts could be a trust like we've been talking about. They could be special and supplemental needs trusts for the benefit of a disabled child. Long-term care insurance, I would let Doug and Tim talk about this. You should talk to them or Ralph about this. You know, long-term care insurance has kind of evolved over the years, and you know, the old traditional long-term care insurance, policies were not. They were pretty good. Then they kind of declined for a while, and then they started putting, I think, riders on life insurance policies that you can get, which I think are okay, or they're better than what they were for a while there. But the point with this is that you really should talk to an insurance or financial professional. I mean, Doug, Tim, Ralph know this stuff. This is not my expertise. This is something that, or if you have policies already or your parents have policies, have them look at it and see what the benefits are, because a lot of times it's very confusing. So, and it's not entirely clear what the daily rate would be on these. Gifting, you know, when it comes to people that get a little bit older, you know, I would rather see outright gifts, joint ownership gifts. If you're 75 years old and you put your kid on your bank account and 10 years later you end up in a nursing home, this is one of the very few exceptions, and this is something that Department of Human Services in Pennsylvania, a lot of lawyers that do this don't understand this. But if you're 75 years old and all of a sudden you put your child on your bank account with you, it may only be subject 50% of it subject to inheritance tax in Pennsylvania, because that's the position that Department of Revenue takes. But Department of Human Services takes a different position. And even if you had your child on that account for the last 10 years and you're outside of that 5-year look back, they don't care about bank accounts. They look to the source of funds. And if your child put $0 in that bank account and you put all $100,000 in that bank account, all $100,000 is an available resource, regardless of how long your child has been a joint owner on that account. So you cannot protect half of your account from cost of long-term care by putting a child on it. You might be able to protect against half of it being taxed, but Department of Human Services takes a very different approach to this. So we don't like joint ownership as a plan, because it's not really a plan. It can cause a lot more trouble. I know for a fact Doug has seen it cause trouble before. We've been through this. So there's that. Keeping all the estate planning documents, especially the power of attorney, updated is really important, because there's gifting provisions in there. You definitely want to make sure that the agent is authorized to engage in planning on behalf of the agent's engaged, authorized specifically to be acting on behalf of the principal with respect to long-term care planning, in particular the gifting requirements in Pennsylvania. If they don't have authority to do something under the power of attorney and they try to act on your behalf or you are agent, you're trying to act on mom or dad's behalf, and you don't have specific authority to do that under the power of attorney, Department of Human Services can invalidate the whole entire plan just because of that. So that's important, just to make sure that those things stay up to date. Just want to make sure we got enough time here. Again, annual exclusion being $18,000 a year for gifting. That's a federal law, a federal regulation that governs that. For purposes of Pennsylvania, Department of Human Services only allows $500 a month to be gifted away, and anything more than that can cause trouble when mom or dad, or you apply for Medicaid benefits. They can cause penalty periods, and that is not $6,000 a year. That is it's not cumulative. It's $500 a month. So crisis planning isn't really planning at all. You can choose to spend all the money down and get it down as low as possible. And by the way, if your spouse goes into a nursing home and you decide to spend the money down, the spouse that's not in the nursing home will be able to keep, as of this year, I believe it's about $154,000 right now, a maximum of $154,000. So it's 50% of the available resources, with a maximum of 154. I think the low end of that is around $100,000. So not much money. So not planning isn't really a plan at all. And I always say that. Same thing with crisis planning. Not planning isn't a plan. Spending down your money is not a great way to do things. You should be trying to take advantage of whatever permissible transfers you can. But there's really not many. Once you're within 5 years, you can make transfers to your spouse. You can make transfers to children who are under 21, children who are blind or disabled, or a trust for their benefit. There's just not a lot of options, unfortunately, there. Medicaid annuities are usually the biggest way to do this. Basically, you take whatever is an available resource and you turn it into an annuity payment, either for the surviving spouse, which you can basically take everything up to about $750,000 and convert it from an available resource to a Medicaid qualified annuity that pays out to that spouse that's outside of the nursing home over the course of, say, a 5 or 10 year or even shorter period. That's one option. Or if you don't have a spouse, you can engage in what's called half a loaf gifting, where you can basically, or gift annuity strategy, they used to call it half a loaf, where you can basically give away half of the money to the children and purchase a Medicaid annuity with the other half. And that would render you eligible for Medicaid benefits at some point in the future. It wouldn't trigger any really nasty penalty periods or any bad results. This is not, it works if you need it. It's not a great way to go. Personal care contracts, if you're taking care of mom or dad, you should be getting paid for that, quite honestly. Having a personal care contract is necessary, though, if you're going to get paid. Otherwise, they will consider it to be a gift, and you'll have to make an argument why it's not a gift. But having a contract in place saying that mom or dad who might be living with you, if you're providing the level of care at, like, say, assisted living or independent living, you can basically charge them the same amount that a facility would be charging them, and it'll be perfectly fine. But you got to have a contract in place. And just generally, crisis planning is more expensive. Doing things at the last minute usually is. Think about like buying plane tickets. If you buy a plane ticket a month in advance, it's usually more affordable than buying one the same day you need to fly. So, like everything else in this world, there's a premium for convenience and for making something a priority. So